talk with some legal perspective on the DACA decision of the Supreme Court of the United States with Carrie Severino, president of the Judicial Crisis Network. Carrie, how are you?
Can you hear me now?
Yes, I can. Perfectly.
All right.
Thank you very much.
Doing
How
well.
are you doing?
Doing really well. It's a disappointing week for the Supreme Court, but other than that, everything is good.
Absolutely. So let's start with today's decision on the Deferred Action for Childhood Arrivals program. We just heard from Anna Giratelli, reporter at the Washington Examiner, who gave us some of the basic facts about this. But what's your legal takeaway?
I think this is really concerning to me because I think we're seeing a pattern of the courts being used as a partisan weapon against this administration in particular. And this is another example of Chief Justice Roberts being complicit in that politicization of the court, really. You had this case where we're dealing with the DACA program, but just a couple of years ago, the Chief Justice agreed with several of the other members of this court that the DAPA program, which had a very similar basis for it, was unconstitutional. And now you have him saying that actually, even though DACA, presumably it's equally unconstitutional, the government has to jump through a series of hoops in order to actually stop enforcing a unconstitutional program. I mean, that is bizarre to me that you would create procedural hurdles and roadblocks to stop doing something that's illegal in the first place. The only difference that seems to be between his decision in the DAPA case and his decision in the DACA case is the identity of the president, and that's a real concern to me, to see a different standard being applied to President Trump than was applied to any previous president, really.
So Justice Clarence Thomas seems to echo your sentiments in his dissent, joined by Justices Alito and Gorsuch.
Yeah, absolutely. He said this looks very political. It seems like the court's trying to avoid making a controversial decision here. But you know what? That's something that ultimately is going to get the court into even more partisan and political trouble. You can't dodge important issues the court is supposed to decide by simply kicking the can down the road, as he did here, as the chief has done in the census case before this. In fact, what that does is turn the court into a much more political actor. And that is going to be very bad ultimately for the institution of the court as a whole. And certainly it's bad for the rule of law to have a double standard here where you apply it differently to the Trump administration than to others.
You know, what's so striking to me is that this was a program put into place unilaterally by the President of the United States, not by Congress. And then the President of the United States today, or the current President, Donald Trump, says, we're getting rid of this executive order, in essence, that Barack Obama, the previous president, had put into place. It seems logical to me that a president should be able to rescind another president's order, especially if it is unconstitutional, Administrative Procedures Act or not.
Oh, yeah. I mean, that's what Justice Thomas's dissent was really saying. He's like, look, this was put into place by a memorandum by President Obama. It is bizarre to say that you can't then, if that's all you did to put it into place, how is it that it requires more to get rid of the program than it did to start it in the first place, especially when the program is simply not legal. And you don't need to give a huge, analysis of all these different reasons you're rescinding it. Saying this program is illegal in the first place, that should be enough. That should say it. There were a couple other dissents. Even Justice Alito had another dissent, and then Kavanaugh said, "Okay, even if you said that this is not illegal and void ab initio," he went through and said, "Look, they even did do enough analysis here. Why is this not enough analysis?" So there's this case should have been decided so many ways in favor of rescinding the DACA program that it's really shocking to see the Chief Justice yet again tie himself in knots trying to come up with a reason. And again, all this is really doing is requiring the Trump administration to go back to the drawing board, write up a whole, show your work is basically what they're saying. Except for that when you already have something that is clearly illegal on its face, you don't have to show any more work than that. So I think what the majority is saying is, well, just go back to the drawing board and give us some more explanations. But who's to say they won't have some other political reasons to find fault with those explanations when they finally come up with them again? This has taken literally years of litigation, and that seems to be the strategy.
Again, we're talking with Carrie Severino, president of the Judicial Crisis Network. And one thing that it seems to me, Carrie, that is the case about Chief Justice John Roberts is that he seems to be, more than anything else, more than some kind of conservative, for example. In decision after decision, we see a lot of instances where he's not operated as a conservative justice, but he seems to be an institutionalist first and concerned about the perception of the Supreme Court in the public eye. At least that's how I have tended to look at a lot of what Justice Roberts has done. Chief Justice Roberts has done as Chief Justice, especially since the Obamacare decision. What do you think about that idea of an institutionalist first?
Well, I think that is kind of how he thinks of himself, as somehow protecting the institution. Here's what concerns me. What he is doing is not helping the institution of the court. It is hurting the institution of the court. The best thing for the court as an institution would be for it to have a reputation of abiding by the law, the rule of law, applying it fairly and even-handedly to parties, whichever side of the aisle they are on. What we have here is a court that's acting very politically. It's acting politically, ironically, in a way, in order to try to avoid particularly people on the left in the media saying that they're political. So they know that anytime they have a decision that might be in favor of the Trump administration, they're going to be called political. So they do kind of a reverse move and say, well, let's rule the other way, and then they won't call us political. The bottom line is that is still the politicization of the court. You know, a few years ago, Justice Roberts had a great line in one of his cases about racial preferences. And he said the best way to stop discriminating on the basis, to stop discrimination on the basis of race is to stop discriminating on the basis of race. You should not have discrimination on the basis of race, whether you think you're doing it for beneficial or for evil purposes. That same thing happens here. The best way to stop the politicization of the court is to stop making politically motivated decisions, even if you think you're making them for great reasons. No, if you're motivated by politics in your decision, then you're politicizing the court, and ultimately that is the worst thing you could do for the institution.
I want to spend our remaining moments talking about another decision I know you've been speaking out about, and that is the Bostick case. The Supreme Court decided on Monday in regards to LGBT discrimination in the workplace. We talked about this with Ilya Shapiro of the Cato Institute the other day, but can you sum up that decision and give us your overall perspective on what the court decided on Monday, Carrie?
Yeah. So what was at issue in that case wasn't, is it a good idea to include sexual orientation or gender identity in our non-discrimination laws? That's what a lot of people have been talking about, but that's not what the court's deciding. That's what the legislature was debating when they're trying to decide whether to add that to the laws. What the court was looking at is that already in the law? And we know there are 21 states have those anti-discrimination protections written into their law. Many federal laws and regulations have those words in. They say, in addition to race, color, national origin, sex, religion, they have added sexual orientation or gender identity. So we know how to add that language. It is a existing concept in American law. The question here is, in 1964, when they wrote a very different language, when they just said because of sex, did that already do it? Did it turn out that all the last 50 plus years of people trying to amend that statute to add the language, they didn't need to anyway? It turns out it was already in there in the first place. The answer is patently no. None of the politicians who signed that, who voted for that legislation, none of the first 50 years of judges who looked at it said there's the same thing is to have discrimination on the basis of sex and discrimination on the basis of sexual orientation. They're just two very different types of discrimination. You can't combine them into one simply but for the goal of bringing in sexual orientation discrimination into the law. There is a way to do that. Congress actually was in the middle of debating adding that to the law as we speak. The Supreme Court got ahead of them and said, we're going to just do it ourselves. That's not the way that our legal system is supposed to function. So, whether you agree or disagree with the idea of amending the law, the question here isn't should it be amended, it is who decides. And it is emphatically the legislature that is supposed to be changing our laws, not the courts.
And it comes down to, at least in the way that both of the decision and the main dissent were arguing on Monday, textualism and this idea of interpreting the text as it was written. How do you assess the use by Justice Gorsuch of textualism to support this concept that he moved forward to uphold it?
Well, look, he tried to give it a textualist explanation. Unfortunately, in doing so, he embraced a very different type of textualism than we have seen in his whole last, decade and more on the bench, both in the 10th Circuit and in the Supreme Court. The idea of textualism is you look at not what you think the politicians might have wanted to do, not what you think the best version of what they could have done was, but what the actual laws were that were passed, because that's the language that was agreed upon by our elected representatives, right? But you have to look at it as it was originally meant. What did those words mean at the time? And Justice Kavanaugh's dissent in that case did a really good job of clarifying the problem with this hyper-literalist, reductivist view of textualism that Gorsuch uncharacteristically applied in that case. He said basically discrimination because of sex. Well, sexual orientation is related to sex, and gender identity is related to sex, and so those are all part of this discrimination because of sex. But that goes way too far. As Justice Alito pointed out, that would encompass things like, well, sexual harassment is also related to sex, but you certainly could fire someone because they've been harassing people sexually at work. Justice Kavanaugh said you need to look at this as the whole phrase, and we know that in context, phrases can be understood differently than this reductivist view. I love the example he gave of the phrase an American flag. If I had a flag of the country of Germany that was produced in an American factory, it's got a Made in the USA sticker on it. Is that an American flag? In one hyperliteralist sense, sure, it's a flag, it was made in America, and it's an American flag. But we know that if in general parlance and in the context of a law that perhaps was dealing with how we treat, for example, an American flag, you mean the stars and stripes. You don't mean just any old flag that was printed in the United States of America. That's what's going on here. He took these words apart. He said, well, it's related to sex, therefore it must be in there. At the time, there was a very clear understanding of what discrimination based on sex meant. For 50 years thereafter, that understanding was equally clear. You don't get to decide you've discovered a new interpretation that never was contemplated by the people who passed the law. There's a way to change the law, and it's to pass it through both houses of Congress and have the president sign it. It's not to simply find 5 votes of unelected judges.
Well put. Carrie Severino, president of the Judicial Crisis Network. So great to have you on. I hope you'll come back. Thanks for taking the time today.
Absolutely.
Thank you. Once again, Carrie Severino joining us, breaking down a couple of these significant cases. I mean, what a week for the United States Supreme Court. I think largely negative. They didn't take up 10 cases dealing with gun rights on Monday. They did this decision today with regards to DACA. My overall view, I think that there should be a DREAM Act of some sort approved, a variation that provides permanent legal status to the children of illegal immigrants, these kids who came here as children, at least, through no fault of their own. But I think it needs to be done legislatively through Congress, not by executive order. And it was very wrongly decided on the part of Chief Justice Roberts, who has a tendency to take decisions that he thinks need to happen and find some way in a pretzel of sorts to create a pretzel in order to arrive to that decision. So today's decision's wrong. I think they should have taken up qualified immunity, immunity for police officers on Monday, as opposed to saying, no, we're not going to take this up. And I do think, although there's a compelling counterpoint case to what Carrie Severino was presenting that we heard from Ilya Shapiro as far as the idea of the Supreme Court's decision here on textualist grounds as to why redefining the word sex is okay should be done in this Title VII, I think it was wrongly decided for reasons that Carrie laid out pretty darn well. I mean, it's not a good week on the whole for the United States Supreme Court. Hard-pressed to find anything particularly good that has been done. You just watched a clip from Jimmy at the Crossroads. Don't miss more engaging, intelligent talk. Subscribe to the Jimmy at the Crossroads YouTube channel today. You want to catch our live show. And I love your support. I got Jimmy at the crossroads, making sense out of no sense. Yeah.